Immigration laws recognize the importance of keeping families together. Did you know that parents can petition for their children to get a green card in the United States? However, you have to look closely at who qualifies as a child because the legal definition isn't the same as what you and I would commonly think. Hello, my friends. My name is Andre Mayer. I'm an immigration attorney and an immigrant myself. In today's episode, we're going to discuss what you need to know about petitioning for your child, such as who qualifies, what steps you need to follow, and what documents are you going to need. Let's get right to it. Who's eligible to be petitioned for a green card? First, a child of a U.S. citizen who falls under either of the following categories is eligible for a green card. So if you, the U.S. citizen, wants to apply for your child, and if your child is unmarried and under 21, he or she is considered an immediate relative and doesn't have to wait for a visa. It means it's a faster process. But if your child is not married and over 21, he or she will need a visa, and it's referred to as a family first preference visa. If the child is married, then it doesn't matter whether he's over 21 or under 21. You're a U.S. citizen, your child is married, he or she is considered a family third preference visa. What's the difference between an immediate relative and a visa case? It just means the process takes longer. How long will depend on a variety of factors, like where child was born and when you're filing and what visa preference category. But don't worry, we created a video that discusses it. You can find the link in the comments below, and where we teach you how to read the visa bulletin. Now, second, a child of a lawful permanent resident or a green card holder who satisfies either of the following is eligible for a green card. So in this example, you are a lawful permanent resident and you're filing for your child. Now, if your child is unmarried and under 21, if you were a U.S. citizen, he or she would be considered an immediate relative. In this example, since you're a lawful permanent resident, your child would be a family second 2A preference visa, specifically F2A. If your child is unmarried and older 21, he or she is a family second 2B preference, or F2B. Take note, children who are divorced, annulled, or widowed are also eligible. What I mean is, if your child is married, well, it falls under the married category. However, if your child is married and divorced, it's unmarried. If the marriage was annulled, or if unfortunately his or her spouse passed away, that's not married and considered a child. Now, let's discuss the different classifications of a child under immigration law. There are several meanings to the term child under immigration law. Which classification fits your scenario will make all the difference. Now, the following are those considered a child in the immigration process. Look, at the end of the day, your kid is your kid, right? But does your kid fit under the criteria of what a child is under immigration law? Well, let's talk about it. First kind is a child of married parents, meaning born in wedlock. The classification refers to a legitimate child, meaning you and your spouse were married when the child was born. In starting the application process, parents have to fill out Form I-130 and provide supporting documents showing your relationship to the child, such as a birth certificate or parents' marriage certificate. Second is the child born of unmarried parents, born out of wedlock. Now, it could be you're living together with the mother of your child for years, but the question really is married or not. What makes this classification complicated is the burden of proving the relationship. So for the mother, we always know who mother is. So for mom, you have to present a birth certificate that shows mother's name and child's name. Keep in mind that your maiden name on your birth certificate could be different from your current name, meaning you, the mother, or might have changed your name when you got married or changed it if you got divorced. It just means we would need proof of the legal name change. For the father, you have to prove that you're the child's biological father. The following are different ways that you can provide that relationship. One is through a birth certificate. You can present your child's birth certificate if your name appears on it as the father. If not, then you go to your local civil registry to get your name added to the birth certificate. Please keep in mind this has to be completed before the child turns 18. Two is through an acknowledgement from other countries. Another thing you can do to prove your relationship is to be recognized as the child's father in another country. This might be accomplished through a civil court, civil registry, or a government body. Depends on the country. Keep in mind, again, this has to happen before the child turns 18. Three, blood test and affidavit from mom is really helpful. So a blood test or a DNA test can be used to establish paternity. And it's really helpful when there's an affidavit from mom saying, hey, here's dad, and here's the proof that dad is dad. That by itself does not mean legitimization. That's paternity. Four, to establish that a father-child relationship existed before the child turned 21. This approach is appropriate in circumstances where the father did not legitimate the child before he or she turned 18. In this case, you must not only prove your biological father, but also that you established a father-son relationship. Under this, you have to demonstrate that you and your child lived together before he or she became 21, or that there was a genuine father-child relationship before your child turned 21. Also, you're going to need documents to prove the existence of the relationship. Here are some examples. Correspondence or letters addressed to each other. Proof of financial support for your child, like checks or money transfers. Photos that show you and your child together. School documents with your name on them. Sworn documents provided by at least two people who know of the father and child relationship. U.S. income tax returns showing the child is listed as your dependent. Or birthday, Valentine's, Christmas, and other holiday cards that were sent and received. But before we continue, go ahead and click the thumbs up icon below and hit the notification bell to keep yourself updated about our new immigration-related content. Now, let's go back to the classification of a child. The third way is legitimated child of recently married parents. This refers to those children who were born out of wedlock, but before the child turns 18, his or her parents got married each other. If you're the mother, you just provide your birth certificate to prove your relationship. But if you're the father, you must present the birth certificate together with your marriage certificate. Fourth is a stepchild. This refers to a child whose either mother or father was married to another person who is not his or her biological parent. Under this classification, you'll need to present your child's birth certificate and the marriage certificate showing the marriage occurred before the child reaches the age of 18. Lastly is an adopted child. To be eligible for a visa petition under this classification, you must consider completing the adoption and the procedure before a child turns 16. You should also consider whether the child resides in a country under the Hague Convention or not, because the requirements are different for adoption in a Hague country than in a non-Hague country. Remember, only a U.S. citizen may petition to adopt a child, and it has to happen before the 16th birthday. And the adoption typically has to happen abroad. Now, what is the steps to petition for your child? Step 1, complete Form I-130 with supporting documents. To begin the application procedure, you have to mail the petition form to the USCIS. Form is I-130 petition for alien relative, and it has to be accompanied by the following supporting documents. Child's birth certificate, parent's marriage certificate. If you're the father, petition for your child who was born out of wedlock, provide evidence as described earlier. Documents demonstrating the parent's citizenship or permanent residence in the United States, the Form I-130 filing fee, and don't forget the passport photos. The above mentioned documents are applicable to all classifications except for adopted children, who will also need the following documents. The adoption decree that indicates the adoption was made prior to the age of 16. Documents showing legal custody for at least 2 years. Documents providing that the adopted child has resided with the adopted parent or parents for at least 2 years, such as school and medical records. A child's birth certificate indicating the adopting parent as mother or father as a result of an adoption decree, and documents indicating the parent's marital status. Here's a tip. It would be ideal if you include a cover letter explaining what type of petition your submission is. You can also add the list of evidence that you're going to be submitted to USCIS. And if you have to argue that somebody's adopted or not, summarize your argument in that letter. The benefit is it makes it really easy for the officer to review and to understand your case and hopefully to approve your case. Step 2, file the I-130 petition. For children of U.S. citizens who live overseas, the parent can create an account and file online at uscis.gov or mail the visa petition to USCIS for the state where you live. Once the visa petition is approved, the matter will be taken over by the U.S. Going to go to the National Visa Center and from there to the consulate in the country where the child lives or embassy for application of the immigrant visa and green card through consular processing. For children of U.S. citizens who live in the U.S., the application can be accompanied by, I'm talking about the I-130, can be accomplished by the form I-45 application to adjust status. The benefit is the child will be interviewed inside the U.S. and will get work authorization and a social security number before becoming a lawful permanent resident. However, if the child is not eligible to adjust or has spent time in the U.S. illegally as an adult, consult with an experienced immigration attorney to better assess your case and determine the best course of conduct going forward. And that summarizes the process for petitioning for your child and who qualifies as a child under immigration law. As a parent, you want your child to be with you and keep the family together. If you're having difficulty in petitioning for your child or simply need assistance in your family's immigration journey, you can give us a call and we'll schedule an appointment. Remember, every case is different and we won't take your money if we can't help you. If you found this video informative, please like and share it with your friends who are also considering to apply for a green card. If you have any ideas for future videos or would like me to talk about a particular immigration-related topic, go ahead and let me know in the comment section below. Until next time, stay healthy and be safe.